Hey, it's another exciting video from your old buddy, attorney Brian Parker. I had some questions and comments about my Linchpin litigation, not to be confused with pretzel litigation, but they're one and the same, essentially. So what I wanted to do is delve more into Linchpin litigation by looking at other documents that you can look for the linchpin in. So let's actually put up for 10 seconds the video, Cindy, we did on Linchpin litigation, Shazam. And you can see there, and let's get rid of that. Is it 10 seconds? Yeah, sure. Boom. So today's video, like, love, and describes, get that out of the way. We're doing great. You're doing great. Hopefully we're helping everybody. Again, I want to look at some different models, different motions, not just the complaint. There will be a couple of complaints, but I want you to see the linchpin litigation in everything that you see. So for example, when you're sued under an account stated statute, you'll get an account attached to that, an account affidavit. There's going to be problems in that. So you look for the linchpin of how to attack it. Same with the complaint. As we said, with most pleadings, there's one or two paragraphs which are, if you get rid of them, you get rid of the whole thing. So let us take a look. The first one is a summary judgment. This was filed in Florida, and this is from a Discover Bank. So let's put the first page, number one, up there. Cindy, Shazam. And also, so you totally cover up this face, put up page 2, Shazam. And it's a very simple motion. This is what passes for litigation down in Florida. We have maybe 4 pleadings, 4 parts of a motion. Motion is, at least what I'm experienced with, I'm in federal, state courts, all over the place. And this is about as clean and concise as it gets. And if you look at paragraph 2 of the first page, Cindy, let's just try and do an emphasis also of 2. And their whole linchpin of this motion is this paragraph that they're devoting to the affidavit, as they say, filed by the plaintiff. And this is weird, but again, we've talked about this flowery language that is nonsense. But they say affidavit filed by the plaintiff vehemently substantiates the obligation forming the subject matter of the suit. To put that word in there makes absolutely no sense unless there's an insecurity that you are right or you have conviction in what you're saying. Why do you need vehemently substantiates? It's quite interesting. The word gives away the fact that there is an insecurity there. So you key on that. So in that paragraph, they're saying, hey, go look at our affidavit. And so we will look at the affidavit because it must be a good one where it completely wins the case. So let's take a look. So Cindy, I think I've marked it number 3 for you. Put both pages up. Shazam, the first page of the affidavit, and Shazam, the second page. As you can see, the third paragraph, this affidavit is made on the basis of my personal knowledge as well as my review of documents held both by Discover Bank and Discover Products, and is admitted in support of the plaintiff's suit on account against the card members. Now, why am I looking at that? That's your linchpin. Why? Because they're introducing a company called Discover Products, who by the way, are not in the complaint that they allege, is in the complaint. Interestingly enough, usually these things are signed well before the lawsuit is filed. In this case, this affidavit was signed 19th July 2024 after the lawsuit was filed. By the way, when an affidavit in litigation is signed after litigation is started, it's considered hearsay and not reliable because it's done for the purposes of litigation, which is a hearsay document, and it's not credible. It's one-sided, and so therefore it has to have a real strong exception, a vehemently strong exception. I digress. So who is Discover Products? And if this is Discover Bank's debt, why is the word debt not in the lawsuit or in this affidavit. So though that paragraph 2 is your linchpin, you get rid of that, or you say, why is Discover Products there? Because it's a securitized trust, and that's the servicer, not the owner, the servicer. Discover Bank gave this thing away a long time ago. And again, if you look on the bottom of this first page, you'll see more. Your linchpin is looking at Discover Products there, and why they are part of this deal, I don't know. They're not in the lawsuit, in spite of the fact they say they are. So you'll focus on that in your response to your motion. That's the linchpin. By the way, there is a, that last paragraph on the bottom, it's mentioned a cardholder agreement, and the cardholder agreement indicates what's called the governing law. And Cindy, take down those 2 pages so you can see me. Yay! And put up page number 7. And there is what's called the governing law. And the governing law says this case belongs in Florida. Oh, no, it doesn't. It says this case belongs in Delaware. So why are we in Florida? This is a Florida lawsuit, Florida motion that they're referring to. So if this person, as she swears under oath, is fully familiar, they use the magic words, personal knowledge. That's everything that needs to come in with a hearsay exception under every state's 803(6). That's the exception to hearsay, business records exception. Has to be viewed and has personal knowledge of the person that's signing under oath that thing. So if she, as she says, is fully aware of the person and has personal knowledge of the records, how does she not know that this belongs in Delaware when she cites it too? So that's some fun things. More interestingly, put up the first page of the complaint, Cindy. Shazam. And I've circled their reference. Plaintiff relies upon the choice of law provision contained in the subject agreement. Attached hereto is the substantive governing law. It does not, because it's in Florida. It's supposed to be in Delaware. So it's a very weirdly constructive complaint. And then in Florida, whether you want to hear the motion right away or not, and generally you don't, you file that summary motion right away. I see that cardholder, Discover, creditors, debt buyers always file the summary motion early to scare you into settling. But it means nothing until they set the hearing, and sometimes that takes months. But this is an interesting document. We're looking, that's the linchpin. Usually linchpin also means deception or making stuff up. But linchpin here is interesting. They're focused on things that actually contradict their own document. So let's look at another cool one. This is an LVNV funding affidavit. Cindy, put up the 2 pages. Shazam, shazam. I will tell you, I had a case. They filed a motion for summary. I said, why are we here? They don't have proof. They don't have proof. And it was a Citibank creditor to several companies finally get into LVNV funding. If you've looked at LVNV funding, you'll see they have all these weird entities resulting in somehow getting to LVNV with no proof. So having said all that, they filed a new affidavit saying, Parker's wrong. And of course we own this debt, and here's the proof. So you see that first page, Shazam, and that is fill in the blanks. How do I know? Because they're literally filling in the blanks affidavit. Boy, that must be very good. Well, here's the first problem with that, and it's the linchpin. In fact, every paragraph is a linchpin. It's a Citibank originated loan, which this person should know because they say they have knowledge of the whole thing, although they only say it for a company called Resurgent Capital Services. I'm not sure why they haven't included the original creditor, which is Citibank. And you can see I've typed in a note, no Citibank. That's the linchpin of destroying that affidavit. But the really good thing is page 2, Cindy, Shazam. I've never seen this before. So it's no big deal, but it is a big deal. There's no date on a sworn affidavit. Even the person notarizing always puts on this day, before me, Miss Smith, presented her ID, and yep, that's her on July 13th. There's no date. There's no accidents, by the way, in debt collection. There's mistakes and there's purposeful deceit, but there's no accidents. If they don't have a date, they can very well say, yeah, this came before we filed the lawsuit, Your Honor, so it's not hearsay, meaning it wasn't written for the purpose of litigation, it was written for the purpose of proof. So that's no accident that there's no date on an affidavit, which I've never seen an affidavit without a date. It isn't even an affidavit without a date. How do you know when it was signed? Just about all statutes require there be a signature and a date, of which it is quite missing here. So that's your fun look at another linchpin litigation. The linchpin here is the lack of a date that destroys the affidavit and the lack of any mention of the original creditor. If you got a debt, you know who you got it from. So that's your linchpin there. Let's look at a good one. This is another Florida one, but UHG 1 LLC. Put up the first page, Cindy Shazamsky, and you'll see right now, C6. This is gonna be a fun one, by the way. 6 says, my client entered into a promissory note, the contract with the plaintiff or one of its assigners. If you own something, you know how you got it, how you purchased it, and the name of the guy that gave it to you, or gal, or company. A copy of the contract is attached here too. No copy is attached. Secondly, it's a credit card statement, yet they put the word promissory note. What's the difference? What's the difference between black and white? Eggs and bacon, they're not the same. Promissory note is something where both parties get together, you sign, and you agree that a certain amount of money is going to be borrowed and a certain amount of money is going to be paid every month. A cardholder contract is what's called an open-ended agreement where you have a balance and it could increase or decrease and you make certain amounts depending on if you've got all the money in your pocket or you don't. So it's a credit card agreement that they've called a promissory note while at the same time saying they own it but can't name who the owners are. That's the linchpin that you are focusing on. If that goes away, the whole case goes away. So you can knock that out quite easily, and it was in my counter affidavit. The other fun thing in this case anyway is, this was fun for me anyway, I hope it's fun for you. They attach a billing statement and say, yep, this is proof we own it, here's the guy, I'm gonna put it up. I feel a little weird about this, but it's not improper Shazam. If you go to the bottom, I've left the gentleman's name, I think, or it might be I'm not sure. That's nobody that I know of, and nobody knows if that's even real. That's not my client's name. I always blur out my client's name, but that's not my client's name. So the documents they use to prove he's used the debt, by the way, this is a credit card, it's not a promissory note, is not even my client's name. This is what happened. So put up the bill of sale and assignment, Cindy, number 3, Shazam. And again, as we talked about dates are important. You can't sign off on something and have it be effective unless there's what's called in the law an effective date. So an example of an effective date is this contract will become effective upon the signing and the date of March 17th. So it's an effective date. That's usually in releases, by the way. There's no date here. There's a Terry Bergman, and if you've seen a couple of my other videos on Citibank, that's how do I put this? It's an interesting signature. So, but this is not in the lawsuit. The creditor's name's not in the lawsuit, even though they attach it. Why would they not attach it? That's another interesting question. I'm just seeing if this is actually even a Citibank card. It has no reference to that. So, but this is a Citibank bill of sale for some reason with no master purchase and sale and no date. And how is Mr. Bergman authorized? You have to be authorized to sign for something. There's specific laws in each state saying you've got to sign with authority. You can't just say, yeah, you go ahead, it's ours, now it's yours. You've got to have authority if it's an outside signer. It's a hearsay context. Here's another fun one. Midland credit, that's a very common one. And Cindy, put up the second page, just put up the second page of the complaint, Shazam, and you will look for the so let's look for the linchpin there. I'm looking at the wrong page. We're always looking for the linchpin, the thing that makes this case and ownership possible, and it's number 7. Emphasize number 7, I've put a line by it, Cindy. They're claiming they've acquired all the rights to this debt, and if we want to believe them, let's take a look at the bill of sale, which they do not reference as a bill of sale. They just say there's an assignment, and that's it. So, and then throw a ton of papers. Here's the first bill of sale. It says November 15, 2018, but it's signed 2019 after that. That's weird. It's a Capital One case, they claim. And again, see the signatures? Undated. Having dates on top means nothing. You've got to have the date by the signature for it to be effective. That's your linchpin if you're knocking out the bill of sale. Also, there's no reference to the client's actual debt. Secondly, they add what's called an affidavit of sale of account by creditor. And again, it's from 2018, but it's signed in 2019, and then it's signed in December. And again, no mention of you or your client's name or account number, so it's not any evidence that your debt is being assigned anywhere. This is weird, and attorneys should know better. This is called a certificate of conformity, backing up everything you just heard, and it's signed by an attorney. You really don't know his name, but he's saying, just trust me on the other signatures, they're for real. And he signs, it is not witnessing anything. Like in witness, he says, look at this, put up the certificate of conformity, in witness whereof I have hereunto set my signature. In witness of what? Of whom? Who signed? But if you use flowery legal language, eyes blur on the reader, and then it must be real. He says he's an attorney. There's no proof of that. Usually there's what's called a ticket number, or a bar number, or a P number in Michigan. You'd think they'd want to put that in there to show that they really are attorneys. Then you have the star of the whole thing is the affidavit that Midland Credit always creates. So put that first page up, Cindy. The linchpin right off the bat is plaintiff and defendants. This was signed in, come on. March 15th. The lawsuit was filed 7/2, well before the lawsuit, yet it refers to information such as the plaintiff and the defendant when that's not possible 3 months away from the lawsuit being filed. You're not a defendant or a plaintiff until a lawsuit has been filed. So, and that's signed under oath falsely, but this is what they do. They don't say your specific debt. In fact, they don't even say the name in this case. They don't have the name of the defendant. They have it on top, but in the body of the affidavit where you're making your bones, your proof, they don't put the name of the defendant. So that's your linchpin. Your linchpin also, last page affidavit, Shazam, see it's circled? That's your linchpin. You're saying, hey, wait a minute, this is signed in March, but there's no lawsuit when they call the client a defendant. And also, a lot of states have a law that you can't have an affidavit being true if it's far away from the date of the filing. For example, as I've talked about, in Michigan, it's 10 days. You got to sign the affidavit 10 days within the filing of the lawsuit for it to be considered non-hearsay. So that's that fun stuff. There is another one. I'm saving the biggest. LVNV Funding has filed a motion for summary against a client of mine. So I have looked at the document, and I've, Cindy, see the first document that I've circled as the linchpin Shazam. So this is a page where you're looking for the linchpin. There's several linchpins here that if you knock out, you're going to knock out their motion. But essentially, this is a little weedsy, but just bear with me. Under Michigan law, an assignment must comply with the statute of frauds by being in writing and signed by the party to be charged. So, and then they say a case. And that means when you have a supporting case, that's the court being told, we're right on this. There's a case that has these similar facts and circumstances, and it went our way, which is true except for one thing, and this is what lawyers do. There's a good lawyer. Anyway, so where they say writing and signed by the party to be charged, they chopped out a word, and the word is authorized. So it should say, pursuant to that case, Burkhart versus Bailey, an assignment must comply with the statute of frauds by being in writing and signed by the authorized party to be charged. Well, that's quote unquote from the case. Why did they drop the word authorize? Because who is authorized may not be the person that is signing the document. Claiming, let's go to the next page, Cindy, for the linchpin. Shazam, see that circled document? That's them saying, hey, we got 2 bills of sale demonstrating an assignment of defendant's debt. One from Citibank to Resurgent, another from Resurgent Acquisitions to LVNV. So let's go take a look at this paperwork, because they wouldn't lie to us. I know they wouldn't. So go to, Cindy, the bill of sale and assignment, Shazam, and undated, unauthorized. Authorized party doesn't mean you're authorized, so that's not true. And it's undated. If it is what it is, it should be dated. Gotta understand, and this Brandy Reardon's one of these, they sign hundreds of thousands of these and pump them out, then attach to a lawsuit or in this case a motion, and they just say, yeah, you can trust us. Speaking of trust, this is my opinion. Cindy, put up the transfer and assignment, Shazam. See that signature? I'm going to attach to this the same signature on different documents. And when I say the same, it isn't that this person signs the doc, keeps signing. They're exactly the same. Look at the loop of the J, where the W falls, how it fits perfectly on the line. And then look at all the other signatures that I've attached to this membership website and compare. I use those signatures and when they bring this transfer and assignment with this person signing and say, look, how is he able to say he was in the room signing these when the signatures are exactly the same in February of 2023, March of 2022, July of 2024? How are they exactly the same? And these are, even if these were cut and paste, you've got to say something like that. But it's not the room or place for a cut and paste signature here. They're claiming it's the original signature. I've got that original signature on all these other documents that I'll attach to the membership website. So that is your linchpin of this motion against you. I'll put up all these documents I just showed you with the lines and the arrows so you can take a look yourself. I'll attach them to the membership site. But again, remember, you're looking for the linchpin of anything that's being used against you. The linchpin is what that company or person depends upon to prove that you owe the debt. And then that's what you need to attack or destroy. And I've yet to see them. I've been doing this a long time, and the more they give you, the less chance they're going to win, because there's just nothing. It makes it worse for them the more they give you. So it gives you a way to beat them every time. Look for the linchpin, knock out the linchpin, you knock out the lawsuit. Good job. Thank you. Bye-bye.